rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for argument in our civil number 13-581, Rees versus Hospital Development. Each side will have, excuse me, each side will have 20 minutes in which to argue its position. The appellant may reserve a portion of that time for rebuttal argument. However, counsel will need to keep track of the time for yourself. We have conferenced this case and read the briefs. We're familiar with the facts and issues presented. Would each of you, as you begin your argument, identify yourself and the party you represent? Counsel for appellant may proceed.
Thank you and good morning, Your Honors. Paul Friedman on behalf of Shauna Rees, who's also present and in the courtroom. I can tell you that I'm going to keep this relatively short. We appreciate the fact that you've already read the briefs, and we quite frankly didn't ask for an oral argument on this because I think that it's pretty clear from the writing. But I do
Your
want...
position is there's evidence in this record that the standard of care was breached.
Yes.
And it caused damage.
Yes.
Does it matter the relation of that declarant or declarants to the parties?
I'm not sure
I mean, does it have to be an admission to get you where you want to go, or is it good enough that these statements are in the record?
You mean the testimony of the hospitalist?
Yes.
I'm not sure exactly what you're asking. I apologize.
You've got a couple of statements that you want to use to get past summary judgment. One of them is the standard of care was breached, correct?
Well, and I can tell you that it was not an issue for the trial court, and so we didn't independently get into that. I mean, we have standard of care experts, and they have opined in this case.
You're saying that the only issue before the trial court was causation.
The only issue is causation.
So
before the trial court.
assuming that the nurses or the hospitalist breached the standard of care,
right,
and not calling the surgeon, Dr. I'm not even going to try to pronounce it. Mudaraj, in time or earlier, that there's evidence from Dr. Mudaraj that contributed to the harm to Ms. Rees.
That's exactly
under
right.
Thompson versus Sun City.
That's exactly
now,
right.
If we, and given some as a summary judgment, if we agreed with that and saying, yes, there's a reasonable inference from that testimony at pages, I think, 30 through 38 of Dr. deposition, Dr. Mudaraj's deposition, maybe on to page 39, then the only other issue, right, if I'm correct, is the amendment to the notice of amendment to the complaint about being able to name the hospital's late naming of the hospitalist as a non-party at fault, and you've basically taken care of that by saying, okay, fine, I've amended the complaint. The court allowed me to amend the complaint, and she was an agent of the, alleging that she was an agent of the hospital.
Judge Kessler, I think you're right on all accounts. The only issue before this court, there's two issues. One is causation, and so I don't think the standard of care is an issue. It was not an issue with the trial court. For purposes of the motion for summary judgment, there's an admission of standard of care. Obviously, at trial, there's not. And then the second issue, and you're correct that we amended the complaint. However, there is another issue, and that's not just the prejudice issue, which the trial court addressed, but whether the defendant, in this case the appellee, was diligent with regard to making that amendment.
Assuming that we reversed and sent it back down, you wouldn't be prejudiced by the late naming because you've now asserted that you've now amended the complaint to say that the hospitalist was an agent.
I think that that's absolutely correct. So let me just start off, and I'm going to keep this short, but, you know, it was important for Shauna Reese to be here today because I think it's important as attorneys and as judges that we understand that these cases are not just hypotheticals. It's not just based on the record. And sometimes we lose sight of that. You know, this is a very real person that had a life-altering event on July 14th of 2008. You know, we're now over 6 years later, and we're arguing something that I think was taken care of accurately within the cases. The only thing that I would really like to address, because I appreciate that you all have read the facts in this case, and I think that they're very clear, is that it seems to us that the defendant is relying on LOCI with regard to the language of substantially better chance. And so what the appellee's argument is that because the magic word of substantially better chance was not used by Dr. Mudaraj, the treating surgeon, the case should be dismissed summarily on a motion for summary judgment, and this court should uphold that. But in the LOCI court, in talking about substantially better chance, they refer to Thompson versus Sun City, which is obviously the case that the appellant continues to cite to this court. And what I'd like to do is take it in terms of the actual language used by the Thompson court, which is contained on 141 Arizona at, I believe it is 607, 688 P2D at 615. The actual citation is, defense experts testified that even if the failure to admit caused a delay in vascular surgery, the chances were only 5 to 10% that plaintiff would have achieved a complete recovery with prompt surgery. So you've got 5 to 10% chance. Though unwilling or unable to quantify the chance of complete recovery with prompt surgery, plaintiff's experts testified there would have been a substantially better chance. So what was it that the Court of Appeals was talking about in Thompson? It was talking about a substantially better chance than 5 or 10%. In this case, not only has Dr. Mudaraj testified to a reasonable degree of probability that the sooner that he had been involved, the better it would have been, but it's quite clear and common sense that she sustained 2 significant injuries as a result of being warehoused in the emergency room department and subsequently in the medical surgical unit. That she had a gangrenous bowel, which was an ischemic bowel, a loss of blood flow to the bowel, which caused a removal of all but 3 to 4 feet of her bowel, which is a significant injury. And she was septic, which is a bloodstream infection, which of course gets worse with time. Now, Dr. Mudaraj testified in general terms that obviously an axiom of medicine is the earlier the better. I think common sense dictates to all of us that the earlier the better. She's in the hospital for a reason. She's in the hospital to get cared for. Otherwise, she would have sat at home and withered away and died. Luckily, she survived. But she survived because Dr. Mudaraj got a call from a radiologist, never a call from the emergency room department, that said, you've got a patient in here. And that's why he came in, and that's when he found her unresponsive. Now, there's other issues in here which we've briefed, and that is that the hospital itself lost multiple records. Now, when I say lost, we don't know whether they're lost or destroyed. They've never been produced in this case.
But now you're getting into the standard of care.
No, that's not the standard of care, because those very records in and of themselves would be important to determine causation in this case.
But they relate to, I understand it, those relate to whether someone called Dr. Mudaraj, right?
No. What it relates to is what her condition was in a time capsule at any particular time after 9:15 that morning. It's impossible for us to hire an independent expert to come in and say at 10 o'clock, here's what the result would have been, because we don't have records at 10 o'clock. At 11 o'clock, here's what her results would have been. We don't have records of that. We don't have records from 9:15 until 4 o'clock when Dr. Mudaraj comes in and she's unresponsive. We know that there are noted changes of condition, but there's no physical examination. There's no assessments that are contained. And all of those records are imperative for the causation opinion. So in essence, to say that, those are immaterial, it's only 2 pages when we know it's more than 2 pages. We know that it's at least 8 pages of documents. But those are the crucial documents. And to reward the hospital, they are crucial for the causation opinion.
But wasn't there also testimony? Let's just put aside the records. Wasn't there also testimony that her condition changed?
Most definitely.
And so that, and then, because if I recall, what Dr. Mudaraj said was, at the time that the patient, he's asked, tell us at the time that a patient is starting to exhibit signs of being diaphoretic, pale, vomiting, not getting relief from pain medication. At that time, as a surgeon, in your mind, is there something that telling you that there may already be ischemia that is starting to occur from a bowel obstruction? Witness, yes. Now, there is testimony, besides the records, there is testimony that are missing, but there is testimony and evidence in the record that sometime during that morning or early afternoon, Ms. Reese started to exhibit signs of being diaphoretic, pale, vomiting, not getting relief from pain medication.
Most definitely.
Okay, so at that point, that would support, even that would support a view of, okay, there's something going on. I mean, let's put down to very brass tacks. Something's going south. Something's going wrong. We better call the surgeon.
Absolutely.
Okay.
And that started at 11 o'clock. Now, it may have started earlier than that. We've got a problem with Nurse Major, who indicates, there's no change of status, and yet we know that at the time that she gets to med-surg, she's in bad shape. She's in bad shape, but unfortunately Nurse Brune doesn't recognize that she's in bad
Right,
shape.
but there may be conflicting evidence about whether there was a change in condition, but there is evidence in the record that there's a change in condition.
That's absolutely
It's
correct.
consistent with what I just read.
That is absolutely correct. So I would like to reserve, unless you have questions, the remaining time for a rebuttal, if necessary.
Thank you, counsel.
May it please the court and counsel. My name is John Checkett. I represent West Valley Hospital along with Mr. Paul Sheston. There's no question this is a medical malpractice case. There's no question that plaintiffs certified that expert testimony was needed in order to prove their cause of action. And there's no doubt in your minds or our minds that Mrs. Rees came into the hospital. She had a medical condition, and she ultimately ended up with losing part of her bowel due to short bowel syndrome. And for that, we are very sympathetic to Mrs. Rees. From there, knowing all the requirements that are needed in order to advance a medical malpractice case, the plaintiff in this, appellant in this case, through her attorney, chose not to retain a causation expert. So the causation deadline for listing the expert came and passed. A year later, we deposed Dr. Mudaraj. And Dr. Mudaraj's testimony, I respectfully submit to you, is not sufficient.
Right. Are you saying that Dr. Mudaraj isn't, they cannot rely on the treating surgeon's testimony, deposition testimony,
No.
to show causation?
No, Your Honor.
Okay, so they can do that.
They can.
Okay, you're saying it's not sufficient under a summary judgment standard,
Yes,
where
Your Honor.
we take all reasonable inferences in support in favor of the party opposing summary judgment. And when Dr. Mudaraj, and I've gone back and I've read the deposition testimony, and I know you point to later testimony where Dr. Mudaraj says, in general, the delay is bad. But pages 31, 32, 33 of his is it a he? I'm sorry. Is it?
It is he, Your Honor.
His deposition. I mean, he goes through what I just quoted, saying that if those conditions are occurring, then there may already be ischemia that's starting to occur, and at that point, time is of the essence to open the patient up and try to correct or to remove it. And then when he opened her up, there was sepsis. And so why is that not sufficient under Thompson to say, okay, this affected her chances of a full recovery?
Well, Your Honor, I submit to you that it's a situation where the standard, as I read it, and I believe the Arizona law says, is a substantial chance. We've already interpreted the application of the restatement here in Lose as well as Thompson. So if you have it needs to be a substantial chance. If you go to the thing that the trial court recognizes that I would ask you to consider is plaintiff framed two causation issues here. There's two separate issues. The first issue is plaintiff's causation is only on timing. The first issue is earlier treatment of sepsis would have prevented any portion or a large portion of the bowel from being removed. So if you treat sepsis earlier, it would have prevented the bowel from being removed. That's the first timing issue. The second one is earlier surgery would have prevented or minimized the amount of bowel that needed to be removed.
Isn't that common sense?
Absolutely. Well, common sense in this way. If you look at Dr. Mudaraj's testimony, and let's go to the sepsis. If earlier treatment of sepsis doesn't mean the bowel is saved. And if you look at Dr. Mudaraj.
Wait, we're careful of that. Bowel is saved, meaning what? That no bowel has to be removed?
No bowel or less bowel. It's minimized. The injury in this case is significant portions of the bowel was removed. So that's the injury that we're talking about. So what is the causation to say that earlier treatment of sepsis would have prevented any bowel, some bowel, lots of bowel from being removed? Where is that? And I submit to the court, if you read that entire, in Judge Kessler, I think what, it seems, and I respectfully submit, you're focusing on is, well, there was sepsis here. That's the end of the case. And treatment of sepsis earlier is better. You look at Dr. Mudaraj's testimony on page 31, line 23. It says, and this is from appellant's attorney, and would you agree that at that point in time, they're talking about 11:40 in the morning, to go in there, open up the patient and try to correct the ischemia or remove the ischemia as quickly as possible so that more of the bowel does not become ischemic? Dr. Mudaraj doesn't say, oh yes, sepsis, if you would have treated
qualifies
it.
it.
He qualifies. He said, let me just qualify that a little bit. The extent of bowel ischemia depends upon what was causing the ischemia. There are some instances where you may not see more of the bowel getting ischemic, but you certainly worry about the patient getting more septic.
And then he goes on and says, when he opened her up, she was septic, and it was affecting other organs.
So sepsis is present at the time they open her up, but at what point before?
But it may be septic. It may have been septic earlier. The point is, did it spread?
Well, and
then on page 33, Mr. Friedman asks him, and had you been told that she was exhibiting these signs by 11:40 in the morning, is it fair to say that if sepsis had already begun at that time, that it increased throughout the day until you actually got in there to do the surgery? It certainly is. I don't understand why that doesn't create, why that requires a court to take the fact issue of causation from a jury. I want to be very pointed with you about that. I don't understand why that doesn't meet the standard.
And I'll refer you right back, is if you look at page 11, line 23.
I don't have that, but go ahead.
Okay, the question is, from Mr. Friedman, when you initially got in there for surgery and determined there was a ischemic gangrenous bowel, could you tell or make a determination how long that process had been occurring? Answer, no.
Okay.
So if he cannot tell how long that process is occurring, then at what point, and that goes back to sepsis is a different medical concept, which the trial court understood, than ischemic bowel. You can have sepsis and be sick from sepsis. I could look sick. I could have sepsis. It doesn't mean I have ischemic bowel. So when did those, and that's why not having a medical causation expert outside of a treater who you're trying to rely on to shoehorn him into the case doesn't get you there.
I don't understand why that matters. If then the questioning then follows up by saying, when these changed conditions occurred, someone should have called me immediately. And I'm going to paraphrase a little bit, because I think what Dr. Mudaraj said is, if I had been informed of these changes of condition, I would have been down there immediately, or I would have had my partner be down there immediately. And then, and it also says, at that point, time is of the essence, when those changes of condition are there. It sets that up for saying, okay, it got worse because, her condition got worse because no one called him.
But all that sets up is he would have come in sooner.
Right,
It,
but he-
it doesn't set up the causation of if he operated, if he went in and treated the sepsis, as you see from his own testimony. If he treats the sepsis at 11 o'clock in the morning or 12 o'clock in the morning, is the damage already done? And how much more damage is done throughout the day? And this is a condition, Your Honor, that you may be familiar with from other cases, where you've had days of delays.
But let's look at page 38 of the deposition.
Right.
What about sepsis? Once the sepsis begins, I'm looking at line 21, how quickly does the sepsis spread? Again, that's quite variable. Sepsis response can be quite varied. It may take a few hours, it may take half a day. So either way, from that testimony is, it's not, oh gee, this may have been going on for days before that. It is, in this context, within a period of several hours or half a day, that sepsis has spread. And you
Okay.
combine that with the earlier testimony that time is of the essence when these changed conditions occur. I think it's fair to say that creates a fact issue about causation for the jury. That if the doctor Dr. Mujarraj had been given that indication, that change in condition would indicate that sepsis was there and spreading.
Okay.
And time was of the essence to stop that spread.
Okay.
And the delay resulted in a loss of a chance of stopping the spread or of saving some of the bowel.
In what kind of a chance? And that's the difficulty here is you don't have to have the magic words. We're not submitting that you have to have the magic words. Was there, as Lose interprets Thompson, it can't be an infinitesimal chance. There's somebody who needs to quantify it. And in Lose, you had the fire patrol increased.
Yeah. But, fire control is a totally different type of situation. Is the fire going to jump the fire line? Is it, it's unpredictable. This witness is saying this is what's going to happen if there's delay.
The witnesses, and I take you back then to page 33, line 25. At that point, and again, Your Honor, you have to realize the context of this is the appellant is trying to push this expert, treating doctor, to give him opinions that he needs to say the timing when there's last chance. The question is, tell us how fast you know this infection occurs when there is ischemia to the bowel. It is variable. Question. When, with regard to Shauna Rees, could you tell how quickly that sepsis had occurred with regard to her bowel? Or could you tell? Answer, no.
Right, but then he goes on.
And he does go on.
And he says, you want to know about the clinical signs of the patient to know whether you need to go in there right away to make sure the person becomes as less septic as they possibly can, and there's the least amount of ischemia. Is that fair? Sure. It's important to you as the surgeon to be told what is going on with the patient so you can make a determination as quickly as possible whether you need to go in for the surgery to make sure there's the least damage from the ischemia and the least amount of damage from the sepsis. Yes. Would it be important for you as a surgeon to be told what the findings were for any abdominal examination by 11:40 in the morning? Yes, it would be important. So part of the problem is an impossibility. As I read that for summary judgment standard is I can't tell you how long the sepsis was going on because they didn't call me to come in and look at it. If they had called me and said, listen, there's a change of condition here, I would have been there right away, and then maybe I could have made a determination, do I need to operate right away? By the time I get called, the sepsis has spread, the ischemia is worse, I've got to operate. So it is sort of a conundrum, but the problem is, by assuming that he wasn't called, and we have to make that assumption because you didn't move for summary judgment on standard of care, You moved on causation.
Correct.
Assuming that he should have been called and he wasn't called, he can't exactly say when the sepsis began or whether the surgery should have been done, would have helped, an earlier surgery would have corrected all this, but he can say all of this is an indication of sepsis and ischemia spreading, and when I get in there, the sepsis is further along. And that can go for summary judgment standards. Again, remember, interpreting all of this in the light most favorable for the plaintiff is that within a few hours or half a day. That seems to me a fact. I got to tell you, I'm not convinced that is not a fact question. I am convinced
Judge
that's a fact.
Kennedy, I see your point. The difficulty that I believe that I point out with Arizona law is this. You're advancing basically the sooner the better defense on heart attacks, cancer, sepsis, ischemia, everything. So basically, just from my reading and from hearing what you're saying is the sooner the better to treat the sepsis will get you past summary judgment every time, where we have a treating physician who's deposed a year after the disclosure deadline who says, listen, I can't tell you, and that is why there is a certification for medical expert testimony.
But you just,
Well, look, is it, my understanding is, and I don't think you're disputing that, the doctor, the sooner surgery is performed, the better outcome. But the issue is whether, what I understand you'd be saying is that the plaintiff hasn't shown that her condition was any different as of 11 a.m. between 11 a.m. and when the surgery was performed at 5.
Correct.
That's what I understand to be a fundamental premise of your argument. It's not just that earlier surgery is better. Earlier surgery is better only if her condition is different along the way. But if her condition was as bad at 11 a.m. as it was at 5 p.m., then it doesn't matter when the surgery was performed. Is that what you're saying?
Judge Johnson, basically what I'm saying is there has to be proof in a medical negligence case that earlier intervention would have given this patient a substantially better chance of an outcome.
Okay.
And if they have a treating surgeon who comes in and says, I don't know, I can't tell you, and based upon my involvement, surgery 30 minutes before may have had the same outcome, surgery 4 hours before, surgery at 11 o'clock.
That's not what the testimony is. The testimony is, what I understand is that the doctor is saying that if the development is attacked sooner, but if she's what I understand is that fundamental to the plaintiff's case is that sepsis and the development of the infection was a gradual thing over the course of the day. Now, is there any dispute about that?
For purposes of this argument, no.
Okay.
So assuming viewing the most favorable light to the plaintiff, sepsis occurs earlier in the day.
And it grows, it expands, that it more and more of the bowel becomes affected over the course of the day.
And that's where the causation, looking at the causation, is the answer to that is no. Is sepsis, as according to Dr. Mudaraj, is a separate part and is not necessarily related to the bowel. So he said in that testimony I pointed out that you can have sepsis. The extent of bowel ischemia depends on what's causing the ischemia. There are some instances where you may not see any more of the bowel getting ischemic, where you see the patient getting more septic. So the bowel is not, that is a fundamental premise of plaintiff's case, Dr. Mudaraj can't support it. And if they are two different things where you can get septic and I could look sick all day, but I don't have more necrosed bowel like Dr. Mudaraj says, then the amount of bowel taken is not tied to sepsis. It's tied to bowel ischemia, which are two separate concepts.
So your argument is that the plaintiffs haven't shown that ischemia grew over the course of the day.
Absolutely. And if sepsis grows over the course of the day, but you do not have that causal link because they didn't go out and get a causation expert to say who could have viewed this independently and come in and say, listen, the sepsis grew, but you've got Dr. Mudaraj saying sepsis is independent of the bowel necrosis, and it doesn't mean that sepsis is getting worse, bowel necrosis is getting worse. And so that's where Dr. Mudaraj, now I went to the surgery, the things I cited were in the surgery, but that's where Dr. Mudaraj has no opinion, none, in his entire deposition transcript that if you treated the sepsis earlier, it would have cut down on the bowel necrosis. All he can say, and all he did say is, if I would have had surgery earlier, so that's the timing of the treating of the sepsis. Now the timing of the surgery, he says, well, if the surgery would have been earlier, I can't tell you because that basic premise is the sepsis is worsening, the bowel necrosis is not. So that's why you need medical causation testimony.
And what's the effect of any of the missing records on the plaintiff's inability to prove what you say the plaintiff needs to prove?
And Judge Thompson, none. And the reason I say that to you is plaintiff stands up here, appellant stands up here and says, hey, he is no expert who's even looked at the case. All he comes up and tells you is, I can't get it because I don't have the records. Absolutely, there's no expert who says that. In Judge Kessler, if someone has a medical negligence case where they have significant damages and certify they need medical causation testimony and rely on the treater who can't get them there.
But if he can't get them there, that's the issue, because you're not saying that the treater can't. I asked you earlier, could the plaintiff rely on the treating physician
Yes.
to show causation, and you said yes, they could. You're just saying they could rely on that as a matter of law, but the question here is, was that sufficient?
Well, and the last thing I'll leave you with is, where is that step of sepsis, the relationship between sepsis and the ischemic bowel?
Well, I would submit.
Well, we'll ask about it.
Okay. Very good.
Thank you, counsel.
I'm just going to address a few things and leave it at that.
Counselor, could you start with the connection between the ischemia and the sepsis?
Sure. Dr. Mudaraj addresses both ischemia as well as sepsis. His opinions are with regard to sepsis and ischemia. The ischemia is the dying of the gangrenous bowel, so the shortage of the bowel. That is not the only injury in this case. And so, unfortunately, that is Appellee's argument. That's the first thing that he said to you, is that there's only one injury in this case. There's not just one injury in this case. The longstanding effect is that my client has short gut syndrome or short bowel syndrome, but she had multi-organ failure as a result of the ischemia and the sepsis. So there are multiple injuries. She was in the hospital for an elongated period of time with multi-organ failure as a result of this. So it's not just how many feet of the bowel needed to be removed at 11 o'clock or 12 o'clock or 1 o'clock or 2 o'clock, and that's what we discussed with the trial court. It's more global than that. She has both a sepsis and an ischemia, which is the dying of the gangrenous bowel. So she has a raging infection in her system, which obviously is getting worse throughout the day, and she has ischemia, which is obviously getting worse throughout the day.
Well, does as far as the connection between the sepsis getting worse and affecting the ischemia, does page 34 to 35 of Dr. Mudaraj's deposition take care of that? You ask him, or Mr. Friedman asked him, is it important to you as a surgeon to be told what is going on so you can make a determination as quickly as possible whether you need to go in for surgery to make sure there is the least damage from the ischemia and the least amount of damage from the sepsis?
That's exactly
Answer
right.
yes.
That's exactly right. And so Also, Mr. Checkett, he's advocating for his client. We appreciate that. But he says that there's no expert that talks about the missing records in that link. Well, Dr. Dumlau talks about it. Dr. Dumlau is the hospitalist in this case. She's an expert. So I'm not sure where he's getting that. And Dr. Mudaraj addresses the fact that what can he do if he's not called in? He doesn't see any records. He can't say that. What he can say is a general principle, which I don't think we even need a doctor to tell us, which is if you are warehoused in the hospital with an obstructed bowel, you're getting worse, you're going to either get worse continually, and eventually you're going to die from it. Luckily, my client didn't die from it. And just one other thing he says that the surgeon, first of all, he alludes to the fact that he deposed the surgeon. He didn't depose the surgeon. We deposed the surgeon. The appellee in this case didn't do one thing. They did nothing with regard to discovery. They sat in depositions and they asked questions when it became their turn, but they never noticed a deposition. They didn't send out discovery. They did nothing in this case. It was the appellant that deposed Dr. Mudaraj because Dr. Mudaraj was the only one in a position to say what he found and what the cause was. He was the only one in this case because of the missing records. But he also indicates that it was 1 year after discovery concluded, and that's just not the case. You have the deposition in front of you. It was during discovery that Dr. Mudaraj was deposed. So I'm not sure, where that came from, and it's of no relevance whatsoever. I think that this court has a good understanding of this case, and so unless you have questions, we're completed.
Thank you, counsel. Thank you both for your arguments. We'll take the matter under advisement. We'll issue our decision in due course. Court's adjourned.